Sir, it would be a privilege for us to introduce you. So allow Renuka to do that because students here only know you in the capacity of the director of CVT. Keep it brief, Renuka.
Okay, good afternoon all. I'm privileged to get a chance to introduce the resource person for this session. So we have Professor Dr. Chanchal Kumar Singh with us, who will deliver a lecture on development of modern liberal law, the contretemps between predisposition of European laws and indigenous practice. So sir is a professor of law at HPNLU Shimla, and he's also presiding the office of controller of examination for this university. Sir is the director of Center of Comparative Public Law. Under the guidance of Sir, the center has organized various capacity building programs, workshops, and certificate courses. Sir is an alumnus of Delhi University and has 15 years of teaching and research experience. So, apart from university teaching and research, Sir has also delivered lectures at various prestigious institutions. Sir is also the founder and editor of two of the prestigious journals of this university. That is, first is Shimla Law Review, which is a well-acclaimed UGC care-listed journal, and second is HPNLU Law Journal. Before this, Sir has also been associated with the Journal of Law Teachers of India, published by Faculty of Law, University of Delhi. Sir has also been associated with various research projects of the government, such as Supreme Court project on restatement of the Indian laws. Presently, Sir is the principal investigator of two of the project of this university. The first project is role of pro bono lawyering in ensuring access to justice, which is a project by Department of Justice, Government of India. And second is socio-economic rights and rights of building and construction workers, a study of implementation of laws and rules in the state of Himachal Pradesh. So kindly welcome Sir with a big round of applause. Over to you, Sir.
Thank you. Let us start. I don't have a systematic set of ideas to deliver because the topic is such, and topic is both our co-organizers will track. It's a historical, how to do historical studies. I'll start with the importance of historical studies. With a fragment in one of Shimla Law Review paper, it says that it is a sad commentary that legal studies have denounced and have got divorced, delete from studies in history of the community, culture, and history of concepts. When a legal concept is divorced, and you listen carefully, in such ways from history, a very limited conception of rationality is required to justify the resultant automated new notions. So that's where David Hume criticizes idea of reason or a priori idea of reason that Kant was vigorously involved to develop, and that's a gift of Kant to the academic community. Okay. The latter, the new concepts that results without looking at history, or that is that are developed. The latter has a very strong but absolute intrinsic attraction to the extent of enslaving conceptions. It is this kind of justification that lay underneath endeavors of science, natural science. We don't need ethical standards in a way social science require. For example, artificial intelligence, astrophysics, cloning or biological, whatever, sciences, etc. Studies and researches in them, natural sciences, do not involve knowing, do not have to refer back in history necessarily, and are futuristic in nature. So the scientific studies are futuristic. They don't have to go back. These branches of knowledge involve knowing the given that exist by nature or given by cause. Knowing the given and using the known that you have come to know thus far, and are not necessarily concerned with good life. The latter forms the primary object life of social sciences and humanities, since social sciences in general and law in particular do not deal with primarily what is given and are concerned with creating, and this is especially true for law. They are law as a subject of study, as a subject of research, creating its subject matter in the pursuit of its own study. Law is inherently, therefore, dangerous, or a dangerous human phenomenon. I happen to remember a book by Masaji Chipa, but he claims there that is also echoed by many other writers such as Warner Mansfield. You must have heard a name called Warner Mansfield from Schwartz. What he says, Masaji Chiba's book is titled Asian Indigenous Law in Interaction with Received Law. Because most of the Asian countries received law from Europe. Everywhere, lawyers risk falling into hegemonic traps. Studying law risks mental corruption in our deeply troubled world. Now, here, the idea is who are at risk into falling, risk of falling into traps. There are two kinds of lawyers. Or law, one can be called lawman, not necessarily to be trained or must have been trained in law. They can belong to anything. Foxy asked, tell me 5 names of jurists who have not studied law. The idea is, jurist or jurisprudence is not a subject matter of only formal discipline called law. So that's a difficult task, how to divide, how to name those jurists who have not studied law. Now here, I mean by lawmen what Fuller says natural lawyers. We are not referring to lawyers who are compulsory by law, to whom he says transactional lawyers. Transactional lawyers. Now, it is the second class, transactional lawyers, and in fact, I see myself as a teacher producing only this class, majority transactional lawyers who are always at the risk of falling into mental corruption, massaging correction. Now, here, when we are doing research, we are referring to, or our subject matter is not only primarily coming out with some solution to the practical problems a policy or a legislation, positive legislation has. Our main task is to look at the very fundamental categories that organize our social order or political order, including legal system. Now, when we say fundamental categories, we always refer to fundamental law. Fundamental. So lawyers have a tendency to look at constitution, and they are called public law or fundamental law. They will immediately visualize constitution, and in constitution, certain specific set of provisions. Now, there is a person in 18th century, and it's a very popular, well accepted magazine. What it says that with respect to what we call fundamental or public law, he says no other fundamental but that every supreme power must be arbitrary. When we are referring to fundamental category, see that category, for example, equality or independence of judiciary, and has something, a special sanctity, and which must not be tempered. Now, Halifax, Marquis of Halifax, in 1750, in a book he wrote called Political Thought and Reflections, This is quoted in another book by Matthew Hawley. That's a very popular book and a very standard book for any student of public law or political science, right? Public law. Now, he has discussed in detail. What he says that the word fundamental is used for layman, laity, and it has a purpose. In a similar manner, the word sacred is used by clergy with respect to church or religion. The idea is they will keep everything, whatever they have in mind, to themselves, and no one else would be allowed to touch it or temper it. Now, from there, I believe Carl Smith must have been inspired, and he took the idea that what is fundamental in the fundamental or constitutional law. Constitutional law or fundamental law is generally used interchangeably. Now, the passage I read out simply put forth why and how we should not insist on scientific studies only. When you are studying, so there were many participants who were doing their hypothesis on prison. None of the hypotheses related to the very idea of prison, the way Foucault might have thought, or in a contrasting way, Bentham in Panopticon must have visualized. There are many streams. That idea has to be revisited before you go to operationalization of that idea. So, I'll come to the second fragment. You had visited yesterday natural place, I believe. My purpose of choosing that place visit, because if you could have chosen a very virgin land, that would have been very difficult to walk and visit. It was somewhat easy to do. Idea was to see how nature or with nature you can live. Now, this is not a simple question. There are two streams of dominant philosophy competing. There are belief that there is end of ideology, class of civilization, Francis Bacon and others. Idea is, are the two dominant philosophies, liberalism or socialism, essentially different? Do they share much in common and only differ in explanation and detail? What are common? I'm putting a question. What are common views? For example, socialism or Marxism, let us treat it interchangeably. They are not. And liberalism, what are common things? Common principles, beliefs, anything? They are not quite different. Dramatically different. We are taught that they are different. They are not different. What are the common things?
Common thing is human development.
Common thing is
Human development.
human development. Okay. Any other answer?
Welfare is also a common
Welfare.
for the positive liberals.
Anything else? Go a little deeper. How do they share, and what are the shared beliefs by them?
Human liberty.
Human liberty. Marx also at some point says that it's a great achievement. It's a form of idea, but I know explanation of right he will differ. Yes.
Liberalism and socialism, but sir, I'm sorry fail to understand the socialism and liberalism, how they are practiced. They are actually standing opposing to each other.
That's the general belief. That's what I'm going
How they are
to.
practiced.
I'm going to show you that this is not, or this may not be correct. What else?
Practically, it seems they are different, but maybe theoretically, both are speaking
That's
about.
where I'm going.
Yes.
That's a very nice point.
Anthropocentrism.
Yes, louder.
Sir, anthropocentrism, that human being is
That's a very nice point. Anthropocentrism. Very good. That's what you are supposed to do in Pregnano. Many things could be done. Okay. Let me point out some of the similarities. Basic, deep, at deep level. Both of these philosophies are ideologies which today affect uh, deeply the entire world. They are developed in a particular power structure. So look at liberalism. None of the streams of liberalism can think of basic categories or liberal categories. The categories means concepts, ideas. Beyond the realm of a state or autonomous of the powers of the state. That structure of power is little different, but it is exactly present in Marxism and socialism. At some point in time, it is protected, but it is present. Second, both of them claim that their doctrines, be it rights or liberty, property, or idea of man, or human being, idea of ruling or governance, both of them believe that this is the neutral way to look at these conceptions. This is the only way we can conceive of these categories, respectively, both of them. That this is the only way we can see it in a neutral, unbiased manner. Okay. Both are product of same or similar cultural circumstances. In that way, both of them are equally culturally contingent. They are developed in a particular time. So, there is a very nice book by Prof, The Spirit of Concord. In one of the chapters, he talks that in the West, he's talking in a particular context, in a particular theory of a particular concept. But this idea is very general, the way he talks. He says that Western theorists have not created theory or developed theory. What they have found a particular practice in a particular culture of their time, that practice is generalized and raised at a particular abstraction level. And then a claim is reposed that this is universe. This can apply universally. Universally. So that's the point. In all these points, we are missing South. We are missing South culture, South history. Because those two histories are not similar, cannot be similar, not identical. Okay, next point. The most important point what Renuka says, the idea, the way man must connect to the nature and natural resources. Must connect. Marx is not different. From Locke, one of the central ideologue of liberal philosophy or a liberalism, law, because it is his categories of idea of property we are carrying on our shoulders. They are not different. So, if you look at the second treatise of Locke, he says that if anything is left given by nature, abundance, whatever, the way they use, and left to rot and waste, it is unjustified. No? That's where he developed idea of surplus, what Marx says surplus. And Marx also said that it's a unique feature of human being that he can create. That's where the idea of labor plays main important role. And because of this labor and his unique capacity, he has to master the nature. Both the theories wants to master, both the streams wants to master the nature. natural resources for its own benefit. That's another matter that when money and market come. But we are prior to that at the deeper level. Now, if you think logically, nature consists of these all mountains, trees, rivers, seas, animals. Human is one of the animal part of it. You master the other human. It would look like natural, go like logically thinking theories. So it will also look like not immoral or not involving some deeper moral problems. So Locke became popular in his initial part of the second treatise. He raises the problem, deeper moral problem related to idea of property, idea of human being. But later on, he shifts. Okay. Next point is violence. Both theories, idea of violence. Both theories are on the same footing. Dominant philosophy. If you ask an anthropologist who have done studies or a study of some tribal communities or some or historians or historical anthropologists of the past, violence was an individual bias, or a social bias. It was not public. It was not part of public. Now you see the positivism or the monopolization of use of force. Look at the cost in more properly case. So only state through its law can legislate. So both these theories in modern times make violence as a public property of the state or the public power. So that's a great shift they did. Now, if you want to understand this point only, you refer to Paul R. Brass, a very nice book. Paul R. Brass, the name of the book is Forms of Collective Violence. Collective violence. Do you know Paul Brass? Paul Brass is an American political scientist. He lives for last many decades. I don't know where he is now, but in Aligarh. Aligarh is a place in Lucknow. UP. Right? And after studying in anthropological manner, he has come out with certain generalization theories. I think that fits into. Therefore, what we see that there is a struggle between socialism and liberalism. The struggle is on surface. It's not that deep. So, research endeavors what we make must go to that level. These are some of the conjectural, rudimentary points that are supposed to be. So, but there are certain differences between them at the level. Socialism and liberalism. There are three terms. Liberalism has a weak archaeological foundations. Look at the theories of knowledge and maybe try to understand about it. But it has a strong genealogy, liberalism. If you look at socialism, it has a strong archaeology but weak genealogy. Doesn't go. Look at the genealogy does not go much back, though they repose to another Greek and particularly Greek Rome. But liberals will frequently refer to and more important in law, Rome also. But again, here archaeology means the way they look at the history and what existed at a particular time. It's a Foucauldian idea. Then again, the third Foucault's idea is episteme, the way knowledge was perceived at a particular time and is presented. Both of them, in their respective projects of life, these ideologies, they will try to, and they try to present a particular or unique epistemic, in a epistemical manner, their whole set of ideas. So again here, they will merge, come together, apart from differences. Now, if we look at from this point of view, can there be a way of doing things, research, where neither the archaeology nor the xenology is weak, not supported by history? But now here, if we compare the meta-category, the development of meta-categories in the West and in the South, particularly Indian context, because they are vast and community or territory. State as a category was absent, modern category was absent. We all agree? In the West it was absent. But in the West it starts in 17th century. We all popular modern. But what existed prior to that was not much different in terms of organization of social power. What we generally refer to dark ages of feudalism. The kind of feudalism, that idea of feudalism which prevailed in the West and Western societies were governed or remained under feudal dominance was quite different. What existed in India, a subcontinent. The very idea of a state refers or presents a deeper problem. Now, when Aristotle popularly claims that a man who lives away from society is beast or God, he's not referring here society to social community, but he is referring to the organized power of the states. When you read that, it's very nice, very simple. Most simplest way of defining right, which has survived. Now, in India, state as a political power was absent. Overarching political power was quite absent. So today's state in Indian context can be looked into two halves. One can be called a social state, and other can be called a political state where king is important or emperor is important. In the social state, king has little or no importance. King has the first first consequences of this division would be that the law was not proprietary.
So,
Okay.
can you please repeat the name of the book?
Which book?
So, which organize the power of state? You are telling
Aristotle's.
Aristotle.
Politics. It's a very simple book. It's there in our definition. Okay. When you see Indian context, ancient systems that continue till medieval arrival of Europe, the Turks and Mughals had not been different. So, in Indian context, law belonged to social state, where king had little role or no. Law was not monopolized, so king had little power to make. If you refer to Western feudal system, the feudal lord, king is the ultimate feudal lord, or emperor is the ultimate feudal lord, owner, that is lord of everything in his territory, including human. That's how trade in slaves were possible at a large scale, not at an exception or. So he had power over life and death of everything. This is the ultimate landlord. So it's a landlord system. Feudalism is a landlordism system where majority is reduced to a status of chattel. Right? In India, that is quite different. King is not owner of human being, much less human being, not owner of even land. He is not possessing land also. He has no power to make law. Law exists autonomous and independent of the king antedates any king or emperor. Now, then what is the status of king in eastern or southern society? He is only a protector. He is a protector, and in most of the Dharma Shastras, it's called service provider. Service provider. In West, every peasant or serf is a lower status, is paying rent because he is using the land of the king. In South, in our country, they are not paying rent. There is a very nice book on this point by Eric Stokes, India and English utilitarians. Stokes.
What is the name of the author?
Eric E-R-I-C
Oh.
Stokes, S-T-O-C-K-S.
Oh. Name of the book?
India and English.
India and English utilitarians, which majorly discusses the problem rent versus tax. Rent versus tax. Tax is a compensation for services for India digital. What king used to do, king providing for protection services from outside or inside order problems for road or everything. Now this idea that king is ultimate landlord, that played a very important role in development of modern liberal law, whether it started in civil law countries, continental Europe, or common, where the state monopolizes law. I said violence also, right? Violence is not outside. So monopolizes that it played very important role. In India, since it had no time or it was not allowed because of the deception of common law imposition, you can say, of transplant of system or European system, we don't know what would have happened had it been allowed to develop or to be developed by communities. For example, if you look at Western categories, for example, sources of law, and trace it back from today, what theorists, positivists, or naturalists to Greeks, you will find a continuity. So they are similar. Ultimately, they will go back to a state. Hobbes will justify differently. Rousseau will justify differently, but that ultimate anchor is there. Anchor is there in the form of organized power called the state. When you trace in Indian history the Indian law, not the common law, Indigenous law, you don't have such anchor. You can't trace it. And not at all to the kings who are more closer to modern states can be the social state, which was a diffused entity, not organized power. Most of the time you hear village communities. Many Western writers have said that they were not social communities, but political entities, relics, or political relics of ancient time. But that's not true. That's not true. Look at the historians, particularly the Bengalis have done a great job. Ramakrishnan Arsamazundar and Ramakrishnan, when they have written a history of village communities and guilds and societies in ancient times, Srenis or guilds, you'll find it was a different way. Now, when we talk sources, what is sources of law in Indian or indigenous system? Majorly Hindu community, spare the concept. They were also travel, and it's a travel communities and travel territories. The most of the literature converge. So look at Arthashastra or Manu or Rahasati, Smriti. They will converge and they will find only four sources of law. And interestingly, none of these four sources are outside the individual. It's connected and near. So, if you look at the Sanskrit literature and Sangam literature both, they will trace that it's the rules or conducts or principles provided in the scriptures, dharmas, dharmasastras. Then smritis, they are different things. Yeah? Smritis, that is based on memory. Based on memory. Dharmasastras believed to be revealed to someone or some right in Vedas. Smritis, Vedas, Smriti second. Third, Sadachara. It's also called a closer term is Sistachara, but that's there is a difference. Sadachara refers to conventions. It is translated exactly as good conduct of those, or conduct of those, or conduct of noble people who knows Dharmasastras. That's the actual translation. What is the third category? But here it refers to customs or conventions. And then there is a fourth source which it says self-satisfaction. Self-satisfaction. I don't know Kant has studied it or not when he tried to develop duty-based conception of right. Self-satisfaction. These four sources you will find in all literatures. They are converged. Then there is a fifth category, which is practical. Now, all four categories resides in social. It is there. Political or king or emperor has no power to touch it, alter it, because it is binding upon you. It is binding. It was a latter development that Bracton in 13th century said that be thou as high thee. The law is above you. That everything is under the law and God. That's a later development in the West that started new revolution or similar revolution. The fifth category was called Chhatra. Every king was supposed to implement the law that is there. Law that is there. But in the process of implementation, any difficulty can be corrected by executive orders, and those executive orders were called Chhatras. And I think that from where the term Kshatriya comes, because those who rule were called, they are not caste. Now we did that. They are not caste. If you look at Deret says that when a conflict arose, so there is a particular dispute in a particular village or Kashra or urban area, on a particular other different set of people or persons. And conflicting rules are to be found in these four sources. How do you resolve? It goes from below. Chhatra might override customs. Customs would override Smritis would override dharmas. Now, this point is very important. Important for the reason that it simply alone this point can tell you that India had a very developed legal system. If this thing is to be found, it is this thing that most of the European scholars of indigenous law or conventional law in India missed. It was Derek who realized that there is a book called Robert Langa, titled Classical Hindu Law. I think in last pages of his book, he says India or Indians could not develop something like jurisprudence. Something like, because they have an idea, a particular fixed idea. They look upon from the particular perspective, power, violence, all these things. No? So India, but later on, it is this thing that we have to look at. Now, how to resolve conflict? It's not a simple problem. And it cannot be done without having a detailed system of interpretation, a system of methods, and a jurisprudence. So claim by, including Max Muller or similar people, are not true. That's where Said, in his orientalism, was criticizing a particular way of production of knowledge or system of knowledge of the third, not for the third, of the third form. We will tell you what you had. We will tell you what is your history, what were achievements or intellectual achievements your society had been able to achieve. You don't know. You don't know. Because they will come in that perspective we just discussed. Okay?
So 1 minute.
Yeah.
You said this is Chatras.
Chhatra. Chhatra. It's a Sanskrit term.
Oh, KSH.
KSHJTR.
And again, you mentioned about Robert Langa.
L-I-N-G-A-T.
It's written like Lingat. L-I-N-G-A-T. He's a French scholar.
Classical Hindu law book.
Classical Hindu.
And again, Orientalism, you mentioned some other author.
Edward Said.
W. Said.
Edward Said.
Edward W. Said.
Said.
Mm.
So, our purpose would be that even in what Foucault means by term archaeology or genealogy or epistemology, these categories can be applied to historical studies in India or Indian societies prior to arrival of Western parts. And possibly, a simple hypothesis is, neither the archaeology might be found to be weak nor the genealogy. And episteme would be quite different, not absolute but relative. It is this thing that makes Indian society still to be a diverse group. Now, this archaeology can be found in Gandhian writings. There are more people. You can see the big name again, a Bengali writer, P.C. Bhattacharya's. Or some of the Western writers also. It's not about only romanticism or romantic values. So, David Thoreau or Tolstoy. In their writings, we can find a particular way of methodology which is neither weak in terms of archaeology or genealogy. It is unique. Now, I'll show some of the examples how liberal law has developed. Anyone who has studied law is aware that Locke was primarily involved in justifying what was happening in 16th century. And it started happening, that started in 15th. Exploration and finding or discovery, I'm using word discovery. Discovery of new worlds. So if you look at American or European colonial powers, beginning of colonization of new territory, there was not one power. French, Dutch, Spanish, they all were competing. New technologies to cross the sea and everything. So they were competing. And Kant was writing that this is mine because I have mixed my personality by way of my labor into it. Therefore, it is part of my personality, therefore it's my personal property. So it's common to private. Transferring common to private property. Exactly the same thing. There are many powers that are competing. So if you look at the discovery of Northern American country, Canada. So many powers might land simultaneously or happen to be discovering the same thing. Who will claim propriety over it? Who will claim? So Locke's idea was, it's Locke. Locke's idea was the subject, remember, the king's subject or the subject of the king who has first discovered that territory or the property or thing. That thing belonged to the king. Look at it. Subject or officers, even subject. Because he is the owner of subject, feudal category. Because colonialism comes out of the feudal category, essentially. So the subject or the king's subject who has discovered that new territory, that territory belongs to the king. So king will authorize who will rule or whether the king wants to do it. Right. But how to do it? There are many countries competing, many powers, European powers, colonial powers. They are competing. So they found a mutually, now it's politically contingent agreement, not necessarily written one, by amongst all the colonial powers, that you have discovered it first, it is yours. This is the thing, I have discovered it first prior to you, so it is mine. Or prior to all others, it is mine. That's how you have many colonies still in French. In Canada, there are many. No? In US also, there are many. Later on, it amalgamated as a 19th or 18th century. Now, here, it is this background that necessitated development of new principles, including the idea of right, theory of rights, not any particular right, including and specific rights. You have to justify it. You have to construct justifications, and therefore philosophers were compelled to develop these meta categories, what we call today our organizing principles. Property, personality, anything. So these concepts are culturally contingent, historically contingent. It's a particular product of a particular history. It's not a natural thing. Then there are many things that we call it, the theorists propose that it's a neutral concept. It does not have inherent contradictions or inbuilt conflicts. And these are all questions that researchers have to pick up. I'll just show one, but before that, let me tell you how liberal law developed in Britain. So, anyone who was aware of American history prior to arrival of Europeans will find that there were a number of tribal communities, different kinds of tribal communities, and they had formed amongst themselves confederations or federations. So there are 10 tribal communities, they will form one federation, sort of confederation, because they will together protect themselves, protect their territories or pastures or hunting grounds from other confederations. So these things were going on. Anyone who has watched Apocalypto? That is the background. That's a very nice movie. You must watch how it happened. It's another matter that the film producers need to dramatize it. No, they are not historians or academics. So, when Europeans reached America and it became a power, I think 1824, sometime, Crown took from the companies, company of traders, and it had the name and the charter to trade with Americans. So, what happened to the natural resources which belong to Indians, American tribes, those confederations or federations? What happened? Now, Americans brought the idea of before arrival of Europeans in America. Indians had the free hand. Fine, they were not civilized in their perspective, the perspective of Europe. They were not technologically established or organized. That's a different. What they did, they applied the theory of Locke and similar justifications. So everything they have discovered, different parts of American continents, by different colonial powers of Europe. So that territory and resources would belong to that part. One. Two. Idea, these Indians do not have or did not have organized society or organization of society. That's a belief. Therefore, nothing belonged to them. Nothing. They were not civilized. They were not organized. So no natural resource belonged to them. So whatever power has discovered that territory, it belongs to big power, European, East India Company or French Company. It belongs to them. Now, as it as you must have heard the name of Justice Marshall. Justice Marshall, one of the greatest judges of American Supreme Court. There was it's much later, but colonialism is still there. There was a case in first decades of 19th century, 1820s, 18s, 1818 or 18. Idea was everything becomes property of the colonial power. Whatever is occupied by the Indians will belong to the Indians, black people. So it was called right of occupancy. And everything belonged to the power, right of discovery, or it was supplemented by similar ideas called right of conquest or right of war, or right arising out of war, what is produced by the exercise of. Now, Indians can keep whatever by way of right of occupancy, but cannot transfer from one name to another. Land, plants, anything, something. Cannot transfer. They can only transfer to the colonial power. Idea is, this is a civilized rule, and rules prescribed by the civilized organized power prevails over everything. Prevails over. So this is the way they usurped all natural resources and deprived Indians of American continent by way of right of discovery or supplemented by it's mainly Draconian doctrine. It's mainly Draconian in Europe. Whenever the war used to happen, one landlord will be defeated by another landlord. So no law of the defeated landlord, king, the landlord means king, would bind the conqueror. Right? In Arthashastra, there are many verses, and it's a nice verse in at least international law. It says that if a king happens to Arthashastra, Indian context, happens to conquer another kingdom, he is bound by the laws. Look at that one, which is there in that territory, conquered territory. He cannot tamper. He must implement it as it was found, as it was prior to the conquest. He cannot change it. Cannot change it. In right of discovery or conquest in colonial powers, everything can be changed. And unique justification, there is a case called Johnson's and Graham's Lacies versus McIntosh. In this case, the simple idea was a black person transferred into white person. His right of occupancy. Now, the state says you cannot do it. You can only transfer it to the state. That is political power. Now, the same theory or similar theory, right of discovery, was applied when Britishers reached Australia. Because it was said to be terra nullius. Terra nullius. Land belonging to no one. So there were a good amount of, at least in Chanchal, aboriginals. No? Terra nullius. Land belonging to no one. Why? What they see that they don't have a society, they don't have a social organization, they don't have a civilization. So this territory or things found in the territory cannot be believed to be belonging to them, belonging to them. So in Graham's case, decided by Marshall, there are 3-4 justifications they used that we appropriated land belonging to them, whatever, or properties. In lieu of that, we are giving them civilization. That's a sufficient compensation. He uses the term sufficient. This is the thing called white man's body. White man's body, which Edward says criticizes, right? So, therefore, in a recent judgment in 1970s, there were certain claims by Aboriginals in Australia. They had villages, they have survived even after all those stolen children, stolen child. It was called? Stolen children. That was a project by colonizers, no? Civilized. Sociology people. So, in 20th century beginning, the Aboriginals started claiming that this is their sea area or tribal area, this is the land or natural resources. They wanted that these should be again given back to the Aboriginals under the respective term community native title. Collective or community native title based on history. So they are trying to temper the imposition of imposed Western legal system, legal law. That case is called Mabo versus, it's called Millirappam versus Nabalco, 1971. It was decided by the highest court of Australia called High Court of Australia. And Richard Blackburn said that there is no such claims on the basis of, because he again applied right of discovery or right of conquest, only qualified by natives' right of occupancy benefit, or benefits the right of occupancy. So you cannot be allowed. They were trying to invoke traditional claims, or millenniums ancient traditional claims, that their claims do not exist in individual manner, but in the community manner, in which that should go ahead. Quite a different perspective. But by the time 1992, what Australian High Court did, they instituted a committee, commissions, professors, particularly they were anthropologists, because this matter is community title. And the anthropologists were able to establish that they had a organized society, and things or relation of people, community to the things existed in a different manner that European cannot conceive or they cannot visualize. And in Mabo, 1992, High Courts conceded certain rights in favor of the community. But when it comes to Indian system, particularly law making, none of these theories, either terra nullius nor discovery, was applicable to Indian conditions. I'm just showing one example how liberal law is always product of a political conditions, at least when it was imposed on Indian situation. So, conditions for applying discovery was that one of the condition was that the land or the territory where this theory can apply must not already have an organized society, must not have a developed organizational structure or legal structure. So when they came to India and tried to apply similar thing, it failed. There was no justification. So what they did here, because here a well-developed society was there, legal system was there, though they denied it. Because from their perspective, it did not exist in European sense. So everything was there. So what they had to do, they developed a new idea. We are talking of relationship between people and resources, particular triangular. So they had to develop a new idea called act of a state. Act of state. So there is no consistency. Europe में कुछ अलग हुआ, अमेरिका में कुछ अलग हुआ, modern times, Australia में कुछ अलग हुआ, because conditions were different. So they had to develop the theory of act of estate. What is act of estate? Prominently, you study in law of torts also.
Which major?
Hmm?
Which major?
No, that's a different act of war.
Hmm.
This measure is act of war. I'm talking act of estate.
Exempt from any claim when the government has taken an action towards something.
Well, any case you remember?
All the cases of expropriations.
Oh, that can be broadly thought. Very good. That can be broadly thought. But the act of estate simply says that if one sovereign state is acting against people of another people who is not part of it, state, or any other state, no law of that people or that state, another state, can bind it. It's not exactly discovery theory or conquest theory. No law can bind it. Because the idea is, who will decide it? The domestic courts, a state which has acted. Who is domestic court? It is this domestic. The domestic court lacks jurisdiction, right? Jurisdiction to examine the validity of any action taken under doctrine called Act of Estate. And it's a unique product of Indian colonialism in India. So they developed it. This is not a common law doctrine. It's not a European doctrine. Discovery is European. Right? The theory of discovery or theory of conquest or terra nullius, these are European doctrines. But this is developed by Europeans, but compelled by political necessities or social contingencies in the way they found in India. Time there, they were trying to implement. Look at a case called 1959. There is a case called Secretary of State of India versus Kamachi Boy Sabha. 1859.
Sorry.
Kamachi Boy Sabha. Secretary of State versus Kamachi Boy Sabha. What had happened in this case simply? All territories were not part of British Empire in India. They were a small Riyasaddar or Jamindars, princes.
1859.
It was simply like. So East India Company, now recently it had been overtaken by the Crown, 1857 after Mangal Pandey. So East India Company had taken certain action against a Riyasaddar, a prince, Indian kingdom, and appropriated certain property by force. Now that person, that king or that group complained in the Supreme Court of Calcutta. Supreme Court of Calcutta. It is there in appeal from Supreme Court of Calcutta that the Penal Council develops it. So this is an act of a state, and the act of a state, no law of the other country or other people will bind it. It is sold greatly. Now this idea then again was exported all over the world, particularly in colonial setups, so African colonies. So they used it. It is similar to Dalhousie's doctrine of lapse. So political counterpart of this legal idea was therein. Have you heard doctrine of lapse?
Yes.
Jhansi Ki Rani,
Yes,
she was victim of doctrine of lapse.
Yes.
So it was that was a political equivalent, but it was a legal statement that the courts developed. Now, this doctrine today is formally very integral part of common law. Common law. So common law itself is a product of contingencies of political contingencies or economic requirements. Now, I'll tell you the further distinctions and why you should read history. I many years back, I came across for reference. There is a person called Baden-Powell. Have you heard his name?
Edinburgh, US,
Baden-Powell,
US Secretary of
a
State.
scout.
Oh,
He was the founder of
Scout.
Scout family. No? In 1882, he was a British administrator. In 1882, when permanent settlement happened of land, 1793. 1793 by Lord Cornwallis. And who was Cornwallis? Who was Cornwallis?
Governor General.
Defeated Governor General of American Empire, who came to here, no? Who came India. They lost in 1976, 1776. Then the same person came. Now he was influenced by French educators, philosophy, and very powerful philosophy, which believes that the sources of all wealth is land. And that motivated Cornwallis to create a market in land somehow. So entire the traditional system of land and laws pertaining thereto, traditional laws, had to be done away with. One stroke in 1793, they did it by bringing permanent three kinds of settlements. Again, the times were again contingent. Now, in 88, Baden Powell produced 3-volume book, and it's called, and it is that commission that it was a specific task by Government of India, British Government of India, Revenue System of India, Revenue System of India, ancient to medieval. They needed to know how to do it. So they wanted to investigate what were the revenue system of land. Revenue system. Basically, main source of revenue was land. A prime resource of revenue was land. He produced 3-volume book, and it's categorical finding that the company reached eastern coast, and some of the members of the East India Company approached Jahangeer for buying land. For buying, it's a very popular story. This story is found in most of the history books, and it's a true story. So I don't know I forgot the name of that captain of East India Company who reached. So King Emperor was a big man.
Some Thomas Rowe.
Thomas Rowe.
Thomas Rowe.
No, some other name is there. I'm just forgetting. So Emperor was a very big thing. Also, we need a foreign delegation or tradesmen. So somehow he was able that representative. It's a story of 16th century, early 17th, when Britishers have just reached East. The idea was they wanted to buy land and make it our own, not say. Till the time something like had developed, you can buy. So Emperor did not meet, but a minister of the Emperor, Amir Khusro, met him. Met that people. So he said that I want to buy certain villages, land of certain villages, including inhabitants. They will become tenant in their terms, feudal terms, from the Emperor. Amir Khusro laughed. And the Britishers his wife. He said that you can buy a thing from the person who owns it. And this was a shock to them. They were shocked. Because they believed everything ultimately belongs to the king. He can sell. Others are tenant. So intermediary rights would be extinguished the moment king sells it. And they will become tenant of the new owner. He said, no, go and buy to them. Go and buy to the community to whom it belongs. This story is again reproduced and with evidence. And that evidence is also provided by Irfan Habib, Agrarian Society during Mughal period. Agrarian Society during Irfan Habib, great historian, Aligarh based historian. So that thing started there and ended in 1793. Was the last stroke. And Ranjit Guha's book is on this. Rule of Property for Bengal. You must read it. How Ranjit Guha traces the history of land and land rights, particularly, and how it was developed by colonial powers. because of their requirement or exigency. In the process, entire system was Indian system or the existing system was demolished. So when we say that liberal categories, when I say categories, it is basic concepts, are neutral and developed or evolved, this is wrong. They have been produced, determined by circumstances, time and space in one word. So, if you look at the idea of equality, for example, did idea of equality in any doctrinal form existed in Europe prior to 17th century? No.
It is the product of French. Yeah, only for the French.
Modern times, it did not exist. But they were able to organize society differently, fine, feudal or whatever. It did not exist in Indian context also. What was it? Can be a misnomer. Indian history or Indian medical. But does it mean that the things we denote by idea of equality does not or did not exist in India? This is outrightly wrong. It existed. And if it can be revived, my point is, it can be refined and revived, it might be better over what idea we received from French or Europe. Let me tell you 2 points. I said that Indian society structure had 2 parts, 2 halves. One was, or both of them was somewhat, or to a large extent, autonomous or independent of other actors to the extent they needed. Not beyond that, and what they belong to not the political state but the social state. 2 concepts can be traced directly and found in Indian society. But it has to be very carefully understood and derived also. They did not exist in a legal, in a positive legal manner, but in a psychic manner, in a moral manner or psychic manner. But it had immutable status. It cannot be changed, altered, or restricted. First principle can be said to be principle of non-exclusive, or you can simply say principle of access. We are talking in terms of equality, modern equality, which keeps us tormenting. Is there a marble? So we have modern state, all powerful, on the apex of every social institution. It can control and it must control. No one else can touch it. So that state is apex of all social institutions. That was absent in Indian society. You can call it social state, to which law, culture, social norms, practices, and most part of justice administration also belong to this part. And political state, king, emperors, wars, foreign policy, etc. Law did not belong to this. They did not have power. Any emperor did not have power. Now there are 2 things that is important. One, in the social or natural resources also, and there are certain things which are intangible, also belong to this sphere and occupied a particular status. And that particular status determined what law would be. One of the principles was principle of non-exclusion. Or you can simply say it's principle of access without discrimination. That may be, last phrase may be problematic, will come. When you do genealogy, you have to compromise. That's not really non-exclusion. You look at a water resource. Water, there is a pond or a lake, which is source of water as well as source of livelihood. kissing other things, other water products. Now that lake, this thing I'm taking from Chhatrapati. You must have heard. Anyone who is doing anything on water management or water rights, the most essential and scarce commodity that is going to be for the new world, 21st century. Chhatrapati Singh, he wrote a book when he was in ILI, and Bakshi or Professor Viren, they were all studying, doing research. I think it's 7 or 8. It's called Principles of Water Resource and Management. Principles of Water Resource, Principles of Water Resource and Management. Check it out. Exactly. Very nice. If you want to do research, just read this book, how he has taken water thing. It's an entire program shift paradigm for a researcher. Even though you are not doing research on natural resources, you must read it. So look at the way he got it. And what he says that access to this water and water resources. Now there is one village, another village. This is adjacent located. This is located far. Now this it belongs to no one. It's something common heritage of mankind. Or public doctrine. Now he has a right to access. He has also a right, or this village has also a right to access. Only difference would be that right of this village or community has a priority to that village, but it cannot exclude the other. Cannot exclude deriving benefit or accessing that benefit from the other village. So the right, Chhatrapati says, as far as it relates to natural resource, was never conceived as a dominion. ये मेरा है. Had an idea is I can exclude the whole world. Okay? Exclude the whole world. ये मेरा. No. Because only that you can derive benefit. You have a right means simply you can. It's called usufruct in technical term. So right was usufruct in nature, not in terms of dominion. So righty over. So access. It is this non-exclusion or access. It is this thing that can develop into a neutral evolutionary conception alternative to equality, but it would require many changes the way we think of tangible or status of tangible or intangible social goods. Social goods. So it is the status of social good that will determine whose access to what extent, but it will ultimately determine non-exclusion. There would be priority non-exclusion. So in political, it was also found in social, but you can in political you can see inheritance. Principle of inheritance. If you broadly divide equality, these two substances form the modern idea of equality, but it gives a new tenor and substance to the doctrinal format of it. So, inheritance was something which did not directly relate to one's access or inaccess. In the political sphere, it was absolute. In political sphere, right of inheritance, or you can call it principle of inheritance. The principle of inheritance, it was absolute, but it was modified and limited. It had limited status in social state or social sphere. It is two. You look at the two things that can bring out a new conception, and we can call it archaeological or genealogical Indian context conception of history. I'll demonstrate it with another example. And that example is status of the term called education. Not in any technical sense, but in the sense that what is education in terms of the way it exists in society. Okay? It exists in society. It's an intangible thing. Right? And education is, can come into existence out of the community only. Education is a social or public. No? Water to पहले भी exist कर सकता है. If human being is there, society is there or not, then exists prior to that. The way I'm talking of the idea of education, so it's a unique product of the community. You can call it's a product of communal life. And if you connect that product or access to that product education with the idea of inheritance, that's where barriers and filters comes into access to education. आपके पास 50 लाख रुपए थे तो मैं जा सकता हूँ, है ना? नहीं थे तो नहीं जा सकते. I cannot access. So it's directly transforms. Now we can look at the modern idea of equality. None of the tools. No, I keep telling in my class whether I'm correct. All rights to tell me. Article 14 is not a rule. Dawkins says that. Hart fails to prove that this is a rule. It cannot be applied. So the political or legal system had to develop tools. It's called classification, reasonable or legislative, or non-discrimination or non-arbitrariness. Now there is a new doctrine called indirect discrimination. 3 tools you can find, or you can find more tools. No? You don't need such tools because these tools are flawed. It cannot guarantee this. What I am saying, non-exclusive. Cannot guarantee. So that's where we have to work out. No? Look at Delhi Public School. They are appropriated the word public also. They are private schools. Look at the FSME. Okay, that's all. I will stop here. Now the floor is open for any question. No?
I have a question.
Go ahead.
Sir was talking about concept of conquest
Yes.
property. So sir, we have this concept of Section 27 of Limitation Act, which talk about acquisition of property by adverse possession. So can we draw parallel between both these things?
Okay. Under adverse possession,
If we are
what
possessed,
property can be vested?
sir, both the property, whether it is movable property or it is land or house, if,
Can a property, common property be vested?
sir, it says that if you are not filing a case and your limitation period expires, and the other person it
These are
will
all
get.
the rules of common law,
Yes,
and
sir.
you have to see it. But the important point is the concept of seat.
Yes, sir.
Seat. What is seat?
Sir, it's very
That is more
slow.
related to this kind of studies because seat is directly related to a state, no? And relation to the object, no? So that is more important. Any other point? Read.
सर दिमाग में बहुत सारे चीजें चल रही हैं बट क्वेश्चंस नहीं है अपने
Observations are also welcome.
I mean the entire thing you have explained has a parallel in post-colonial histories and theories also. All these things I have also read, but in a very different way. I mean, I'm actually, to be very honest, this was post-lunch. In first 15 minutes, I was finding it very difficult to concentrate. But later on, I could find a lot of parallels, especially with respect to French colonial history. Like for example, I mentioned also in the middle of the lecture about equality, that the notion was developed only for French, but exported to the world at large, and therefore becoming the most virtuous civilizations in the world. And still until today, in fact, most of the people who believe in liberal ideology believe that it is the gift of France. But it is not a gift of France actually. It is actually, it was the way they have developed the supremacy in Indochina back then, before US entered Vietnam. So equality was a notion built by French and rationalized by French writers, philosophers, immediately after Spanish Enlightenment to justify the conquests in Indochina, which led to a lot of atrocities. We know. There's a theory. No, that's not a theory. It's the way historians ironically speak that you don't know who caused the deaths in Vietnam, whether they were French or were they Americans. Why is this said? Is because people in Indochina were so much used to do atrocities of France that they didn't find it outrageous when Americans did it. You know. So what I'm trying to tell you is that even Indians, for that matter, most of the Indians at one point of time did not even realize that this is not the natural fate to them. Also, there is another parallel where we were trying to trace the history of all the case laws post 1818, 1820. So it's a question actually now that is it really related to concert of Europe of 1815 that these colonial powers ultimately came to a compromise? Okay, then I made a connection right.
Also, it's recorded in Marshall's judgment.
Achha.
That agreement, compromise is recorded. It's not simply subjective. Read that judgment. Very nice.
Yes.
Judgment. And it's very, it demonstrates strong affront to your conference. The moment you read it.
No, these people they rationalize in a manner that it gives a tight slap on all those who are against these theories, who understand the basic of it. So, but one thing I think you mentioned, but did not elaborate much was where did Gandhi come into the picture?
Oh,
yeah. We have time, I think so. You can elaborate
Can
on
I
that.
continue for 10
Yeah,
minutes?
yeah, absolutely.
Yes, sir. That
Please.
would be interesting.
Okay, when simple things only. There is an idea. We all know Gandhi was against state, idea of state. He was against idea of this state. Thus far you have got the idea of modern state. No? He was against this state. Why was he against it? Simple question is, why was he against? He said, state is a necessary evil. This was a compromising statement. He was against it. It is in this context that he had said that now independence has been achieved. Let us dismantle INC, no? And make it a social order.
So he was interested in Gram Swaraj.
Gram Swaraj.
Gram Swaraj.
So his idea was not based on power or violence. His idea is, Matunde studies very vigorously that idea. It's called oceanic set. State. His idea of state or organized power was oceanic circle. So from one a smaller circle, the other bigger circle is connected, but it's outside it. It's outside. So this was a system that in the center it will be individual and villages. So he had no modern idea of individual, or conception of individual. The way we know modern idea, was not in that. So here there is a difficulty in this type of analysis. Kantian idea of individual and individual rights or duty. It exactly parallel you will find to that of Kant's categoricals. So that's a great problem. Then to go back to Gandhi and then see that the Gandhi had individualized a different visualized or realized a different kind of genealogy or archaeology of Indian society or Indian system. It's there where I'm focused. My intention was that the state in modern sense would be missing. Neither in the sense of modern sense, the state would have power to make law. The traditional laws. This is a little difficult in the sense that the traditional laws are not all good. They're bad. So what? So is true for the West. They could revive the best things or good things from their bad history or worse history or culture. So the similar selective or refinements need to be done, and Gandhi did it. Gandhi wanted to do it. So that Gram Swaraj, what Sir is saying, it is the very idea there would be a state at the periphery. I said political state was away, autonomous. So he had realized it.
So he has written it somewhere that state should be periphery.
Look at his. Have you read this?
No, sir, I have a parallel here because I read something about core and periphery analysis in Latin American literature also.
Let's see his
Hindu Swaraj.
Hindu Swaraj. And again, Gandhi's writings are published. Do you know how many volumes? It's 100. 100 volume is now given. All his writings, including so he's not a systematic thinker like Kant, who builds system. He was an active actor, political actor. So through his actions, he developed this idea. Now he had a connection or realization of these kind of histories. So that's where I wanted to bring Gandhi.
So state is periphery according to Gandhi.
The modern state, we know that the power will be absent and it will be very.
Beautiful actually. And can I share something?
And this is called oceanic shift idea.
So can I share something?
Yes.
So there is this Latin American theory which justifies, which philosophize how colonialism happens and how the dynamics of colonialism, the colonial power is completely alienated from that of the public using the core and periphery analysis, which these days it is used for MNCs, etc., and the idea of liminal spaces. So what they argue is that there is a core, which is if we understand in North and South debate, it is global North. There's this core, and we all are at periphery. The distance between core, the power center, and the periphery is too large for periphery to understand the dynamics of power. Okay, but to be all powerful, what periphery can do? Periphery has two options. One is they should split their spaces together and occupy the liminal
Is
spaces.
it the extended version of Neo?
Pardon?
New World Political Order?
No, sir. No. It's not that. So I'll tell you the author also. I'm just not remembering the exact author's name. But this particular theory is used by David Kennedy to explain internal legal structures in international law. Okay.
No, here context is different. I got
Yeah.
Here context is different in the sense that we don't have to go to the rationalization to reverse or march. What Western did for constructing a particular set of ideas or system of belief, establishing a particular social order. So Gandhi is very much into the moral, ethical, duty things, and from there, these all things he develops from ancient ethics or practices, and then he constructs them.
Yes, exactly. That's a beautiful parallel I will be concluding with after this. Is that according to him the powerless is at periphery. That's the problem. So what the powerless can do in this theory is that either they can go for periphery cooperation, which we call South-South cooperation today, or they could split their people or their governance in the liminal spaces. Let them occupy the liminal spaces. It means that they should do something that fills the gap between core and periphery, which currently is happening via core in the name of MNCs. MNCs is occupying liminal spaces, and they now have knowledge both of core and the periphery. Since they have maximum knowledge, they have maximum power. So there is a parallel here with which Gandhi argues that the core should be occupied by the periphery, and what the core is in Latin American decolonization theories should be occupied by the periphery, and that in that way the power will really be with the people. So it's like I don't know who precedes whom, but the amalgam gives a very good song out of it.
Mrityunjay, would you want to add something to this entire? Because I've heard Oceanic, I and Mrityunjay discuss a lot, so I've heard this idea of Oceanic Circle. Would you want to add something more to this entire retinue of arguments? Yes,
So nowadays we are reading Rawls, John Rawls' theory of justice, and we are applying theory of distributive justice, trying to understand Article 14 from the perspective of theory of justice, class legislations, and dividing multiple classes and saying that each class is equal. And if equality, a value of equality is only inter-class or intra-class, the question is this. If we limit our imagination of equality only within the class itself and not going outside that class and to understand the relationship between one class and another class, then perhaps Indian constitution would be another Manusmriti and would facilitate only the equality within the class but not equality with relations to one class and another class. So in that sense, Aristotelian idea of distributive justice or Rawlsian idea of distributive justice, talking about class as a distinct identity, but not giving an interdependent relationship, what Sir was referring to oceanic circle. Because when we find an ocean and waves, we find interdependence between one circle of wave with other circle of wave. And in that interdependence, each circle is autonomous at the same time making and remaking each other. But that kind of malleable relationship is quite distinct in our culture since ancient time. And Gandhi was doing that kind of genealogy through which he was trying to discover that value system from India. Whereas a village Swaraj would be autonomous institution, whereas all people living in village would be governed by their customs and logic and law. At the same time, they would not be completely autonomous from the king and their political idea of a state. Where we find a complete relationship between social state and political state, whereas social state is the governing principle of our society. And law is not coming from ever, but law is something constituted in their daily transactions and imitating and continuing with that set of laws by the idea of moral exemplar, what Akhil Bigrami calls, that when you imitate your elders and your elders are doing something good and they are not preaching anything but simply doing something good, so you learn from the experiences of that person being a moral exemplar. So Gandhi was trying to set up that idea as a persona Gandhi, that he is a morally exemplar person, he is experiment with truth, and he is not preaching that my idea of truth should be applied universally throughout the world. But in Western systematic approach to knowledge, what we find in Kant, what we find in John Stuart Mill, that they are trying to universalize their experiences for the whole world and saying that this is a categorical imperative and that should be applied as a moral principle for whole humanity and whole global world. The whole global world. Gandhi is not universalizing his principle. Gandhi is not saying my idea of justice is your idea of justice and global idea of justice. Gandhi is not giving any tool or technique to apply for a global standard. Gandhi is simply saying, I am experimenting with my truth and I am living with my truth in a holistic sense. If it inspires you, then perhaps you can imitate it, and perhaps there is a connection of custom, because in custom we have some element of imitation. So when somebody is doing something good, we imitate that, and that becomes a form of custom. Sometimes it may be also even things may become a custom at the same time, but generally we find that imitation since long time we create that kind of structure. So Gandhi was doing that kind of historiography, and whereas he is not talking about that history, but doing that history, living with that history. This is my view.
So, yeah, just to take cue from this entire session and the discussion that was, and putting into the framework of the topic, where does all this fit in within the frame of the research method? So, as Sir very rightly mentioned, that the historical studies need to be put into perspective, and I'm reminded of two things. First is, there is a chapter on Indian legal history written by Rajkumari Agarwal in the book by Joseph Minator on Indian legal system. There is one very, I would say, for the want of a better word, deplorable paragraph in that. She writes that if you want to trace Indian legal history, you don't have to read anything beyond 1765. That is the statement that is written. I think there is where Sir is trying to hit, that you need to go beyond that as well. And the second point is, if anybody amongst you have gone through this reading material, we have written a statement. Therefore, the technique of research in social sciences attenuated with the sparkles of scientific technique must be reassessed for a view that is not centralized and power driven but diffused and socially pluralistic. So that is the takeaway from the entire session, to put into perspective. And on that note, sir, thank you so much. Thank you so much for this all-encompassing journey. And thanks to the participants as well for being here with us. With that, we come to the close of this session. You can have snacks after this, and we'll meet tomorrow again at 10.
So
Yes.
that thing is from the novel written by Jack. I'll tell you the name, sir. Joaquin, Joaquin Fernandez de Lizardi. His work of 1776. I'll send the paper also. Go for it.
So Marshall's judgment, which one you said about?
Which one, sir?
Marshall's judgment.
Marshall's. It's Johnson's Lacy's versus McIntosh.
Johnson's.
Lacy. Lesser and Lacy